everybody, Stephanie Kropp with the Machine Gun Nest here with our newest legal update. So the update I want to give you guys is regarding ghost guns. No! So this is a term you've probably seen in the news a handful of times. And before I even get into the details of this case, I want to explain to you the reality of what that term means and the misnomer that it actually is. So it is our constitutional right to self-manufacture a firearm. Anybody can self-manufacture a firearm as long as you are a law-abiding citizen. If you're not a criminal and legally permitted to own a gun, you are allowed to self-manufacture a firearm, because at the end of the day, whether Glock or SIG or any of these other manufacturers have actually produced it, it doesn't actually matter or make any kind of difference whatsoever. So the media has actually invented the term ghost gun to make it sound scary. Ooh, ghost, scary, to make it sound like something more nefarious than what it actually is. So when I say ghost gun, I'm just using it in reference to the common terminology, although I completely disagree with the premise behind it. It's just a self-manufactured firearm. So a while ago, there was a case called VanDerStok v. Garland, Merrick Garland, who was the nation's attorney general at the time. Now the case is Bondi v. VanDerStok. And so, you know, Pamela Bondi, our current nation's attorney general. So this is a case that kind of climbed up and went to the Supreme Court and unfortunately resulted in the government upholding heavy regulations on what they deem to be ghost guns. There were two dissenters. The vote was 7-2, and the two dissenters were Justice Clarence Thomas, our guy, Clarence Thomas, he's awesome, and Justice Alito. So the whole entire premise behind this case actually harkens back to a previous case with the ATF in 2022, kind of talking about what actually constitutes a firearm. And unfortunately, we know that they allowed the ATF to redefine firearm to be not only a firearm, which is what common sense would dictate, but anything that could be readily made into a firearm. The problem is this subjective language. What does it even mean to be readily converted or readily made into a firearm? Basically, the way it's standing now is if an ATF agent didn't like you for whatever reason and thought that you had the skills to turn maybe this memory card into some kind of active working firearm, which if somebody had the skills to be able to do that, you could do that, I guess, they would then consider this a firearm and accuse you of illegally possessing an illegal firearm. It's insane because right now that leaves so much power in the government. And the problem is, if you like what the government's doing one day and they have that power, one day they'll have that same power to do what you don't like. So small government is what we want. We want limited government. So whether or not you even like guns or whether or not you even want to engage in these good faith arguments about how we can make our nation safer, at the end of the day, the government holding this much power is dangerous for all of us. So now let's get into the details of Bondi v. VanDerStok. So VanDerStok is, she was the lady who brought this forth. She's somebody who believes in our Constitution. And now this is under the hands of Pam Bondi, which is interesting. It was interesting to see kind of how this would play out, being that Pam Bondi was appointed by Trump, who says he's a pro 2A kind of guy. But we know that due to our separation of powers, it's not like Trump has the power to come in and make some blanket decision on these Supreme Court cases. And that's a good thing that we have the separation of powers. So the crux of it is, and I'll just read to you right here from what the Supreme Court said itself. It says, the Supreme Court upheld a Biden-era rule regarding so-called ghost guns. They're basically saying that these ghost guns should be regulated in the same way as other firearms. Now, I want you to understand something from my perspective as a dealer. When we manufacture a firearm or we receive firearms from other manufacturers to transfer, if you've ever filled out a 4473, those contain serial numbers. At the end of the day, the serial number doesn't really mean that much other than that's that particular firearm's ID, right? But as far as law enforcement is concerned, you know, the serial numbers don't necessarily help in any kind of way. If somebody is driving drunk, whether the car had a VIN number on it or not doesn't matter. Somebody still made the poor choice to drive drunk and put other lives at risk. And the same thing applies with gun crime. Committing a crime, doing something violent with a firearm, murdering somebody with a firearm, that happens whether or not a firearm has a serial number on it. That happens whether or not Glock made that firearm, or if that firearm was self-manufactured by somebody else. At the end of the day, that this issue isn't targeting the true root cause of the issue at hand. And the true issue at hand is that people are broken and they need Christ. And these kinds of laws aren't actually solving the problem they're setting out to solve. What it does is infringe upon the rights of law-abiding citizens, because it is your right, as per the Second Amendment, to self-manufacture a firearm. So let me go through a little bit about the details here. Justice Clarence Thomas dissented from the court's decision, complaining that it had agreed to rewrite statutory text. You see, when we have these ambiguous regulations, it leads to infringement. And boy, have I a story for you about that, but that's for another day. He said, Justice Clarence Thomas said that they had applied the wrong test to determine whether the ATF rule in and of itself was even valid. The ATF contended that the 2022 rule was consistent with the language of the law because it defines firearm to include products such as gun kits that can be converted into an operational gun or a functional frame or receiver. Isn't that insane? So the ATF rule, they're not even trying to hide it. They are literally saying that not only guns are guns, but all these other nebulous parts and pieces, if we want to accuse you of having an illegal firearm, those are guns too. I mean, we're truly living in the world of Minority Report, and this is awful. I encourage you, if you have any connections to legislators, which you do, hop online and contact your representatives. Let them know that this is absurd, because here's the thing, this can be managed at the state level, and your local representatives matter greatly. Let me continue. Let's see, it says there was a group that, there was a group of gun owners, and then also there were some big, groups that kind of went in on this too. Usually this is something that Gun Owners of America, Firearms Policy Coalition, they love to get involved in stuff like this. The Second Amendment Institute, which is right here in Washington, D.C., these guys are awesome at fighting this. So if you could throw them $50, this is how we kind of stop this garbage. But a federal district judge in Fort Worth prohibited the agency from applying this rule anywhere in the U.S. And so 4 justices, and they are Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh, said that they indicated that they would have denied the government's request then. And so they were kind of letting it kind of kick back down to there to see. And so ultimately, this is concerning because we don't want the government to have so much power that they are going to nebulously decide to come after you because you have an object that's not a firearm that they then want to consider a firearm. So unfortunately, this has gone through the Supreme Court, but nothing's ever over till it's over, and this can still, I'm hoping to still see some movement on this, but right now that is the unfortunate outcome of this. We'll keep you updated as anything progresses, and we hope to see you at the range.